Previously, part 1 is focusing on the Malaysian legal system and fundamentals on primary and subsidiary regulation. This part 2 will be focused on two main topics in relation to the legislative process of the three levels of government: federal, state, and local government. This session also will provide contemporary examples of legislation which have complied and undergone the legislative process. I think without further ado, I would like to welcome our speakers today, Ms. Liya Safura Abdul Rashid and Ms. Syafiqah Ibrahim from Zahid Ibrahim & Co., which is a law firm. Welcome, Liya and Syafiqah. Syafiqah. Liya Safura is a senior associate in the Corporate and Government Advisory Practice Group at Zahid Ibrahim & Co., a member of ZICO Law. She has a lot of experience in regulatory reform initiative. Currently, she is writing a book on corporate governance and ethics in Malaysia, which is expected to be published by the end of this year. Syafiqah is a senior associate in the Corporate and Government Advisory Practice Group at Zahid Ibrahim & Co., a member of ZICO Law. She has been involved in advising the federal government and state governments, including various ministries, agencies, and statutory bodies, specifically on law reform. In particular, she is focusing on regulatory impact analysis and preparing regulatory impact statements, please. Ladies and gentlemen, during the webinar participants, you are invited to send questions via the questions box. So please, if you have any questions and clarification, send it to the chat box. The speakers at the end of the presentation will address some of the questions received, and we may not have the time to discuss all of them, but I will group or select some of the questions to represent some of your questions. However, those questions who could not answer during the session, we will try our level best to provide the answer after the sessions. I think we will reply through email. This webinar is being recorded and will be published in our website when it's ready within the next few days. So with that, I would like to invite Syafiqah to do his presentation. Please welcome Nick. Thank you.
Thank you, Alamin. But I will pass so to my colleague Liya Safura. She will be presenting first.
Okay, all right.
Okay, thank you, Alamin. We'll wait for the presentation slides to appear first. Okay, Bismillahirrahmanirrahim. Thank you everyone for coming. Just to a bit of recap, last week we actually talked about the difference, the Malaysian legal system, as well as the differences the scope in relation to primary and subsidiary legislations. So for this week, we're going to look into a few things, mainly on the legislative process, as well as the common features of legislation. So before I start, let's just take a look at the outline of our presentation for today. So as you can see on the outline, for the legislative process, I will be explaining on the legislative process at three levels of government, which is the Parliament, State Legislative Assembly, as well as local authorities. And then my colleague Nick will then present on the common features of legislation, where she will elaborate on the structure of statute, statutory interpretation, and understanding common terminologies that you can see in primary and subsidiary legislation. So for the legislative process, let's take a look at the Parliament one first. Can we go to the next slide, please? Yeah, for the Parliament, this would be the highest lawmaking authority in Malaysia. But before I go into the legislative process itself, let's take a look at some of the related documents that is very relevant in relation to passing legislation in the Parliament. So the first thing first, let's take a look at the standing orders. So for standing orders are basically your peraturan-peraturan for Majlis Mesyuarat. And as you can see in the screen, we have two books here. One is blue and one is red. So for the blue is actually for Dewan Rakyat, as well as the red is for Dewan Negara. As you can see, if you look into the standing order itself, you can see that we actually have 100 standing orders for Majlis Mesyuarat Dewan Rakyat, respectively 91 standing orders for Majlis Mesyuarat Dewan Negara. So the procedure in relation to standing orders is that all members of the parliament are required to conduct themselves in accordance to the standing orders. So the second document that I want to highlight is the Federal Constitution. As you are all aware, if you attended our webinar last week, Nick has explained on the Federal Constitution and the scope of the laws and the powers and provisions under Federal Constitution. But I just want to highlight again that Federal Constitution is the supreme law of the Federation, in which if any legislation that is passed in the Parliament to be inconsistent with the Constitution, then to the extent of the inconsistency, those provisions will actually be void. So I just want to highlight that for a bit. And I'm going to look into the other documents as well related to parliamentary proceedings. So we have Aturan Urusan Mesyuarat, AUM, which contains parliamentary questions and usul cadangan. And the procedure is that daily AUM will be provided to the members of the parliament on the day of the parliamentary sitting. So I just want to highlight like what are exactly the parliamentary questions. Parliamentary questions are generally the kind of issues that we see reported. So if those issues require certain clarification from any of the members of the parliament, especially ministers of the cabinet, then these questions will actually be asked in the parliament session itself. Although it is notable to understand that they actually do have limitation on the number of questions that will be asked in each of the parliamentary sittings. Okay, and for the second document that I want to look into is the vote and proceeding, which is basically your minutes of the parliamentary sitting. So the procedure for this is that this will be prepared by the Secretary of the House in accordance with Peraturan Mesyuarat 9 subsection 3 and 4. And also I just want to highlight there, can you see like there's, if you can see on the side of vote and proceeding, you can see the number 222. That is actually the number of the members of the parliament in Malaysia at any given time. So the third related document that we can look into is also Hansard. So Hansard is generally like the verbatim report of the parliamentary sitting. So it's not just the things that are said during the things that are said in relation to proposal, but Hansard would actually record every single thing. It would even record gestures or the kind of behavior that has been displayed by the members of the parliament, and this Hansard will then have to be published on the next day after the parliamentary sitting. And Hansards are also available on the parliament website. So if you want to look into anything that has been said by the members of the parliament during parliamentary sitting, Hansards will be able to provide you those information. So the fourth document that I want to look into is also the statutory papers. Statutory papers are generally documents such as annual reports of government agencies, which were established and set up pursuant to legislations which has been passed by the parliament. So these are also being used as a reference point in highlighting certain facts and numbers during the parliamentary sitting. So, and this will be the last thing that I want to highlight before I go into the legislative process for the parliament. So we have 4 types of bills that will be introduced and debated in the parliament at any given time. So the first is the public or government bill. We also have private bills, private members bills, and hybrid bills. So how do you differentiate between these varying types of bills that we can see here? So for public and government bill, you have to look into the scope, where usually these bills include bills on matters of general public interest, such as national defense, public order, and taxes. So private bill, in contrast, it only affect certain group of people or certain organizations. Typically, this will usually use, for example, maybe like statutory bodies like Tabung Haji or Perkeso, where if they want to pass any amendment to their parliament to their primary legislations, then they will have to go through via private bills. And the third one is private members bills. So private members bills are those who are introduced by any member of the parliament not necessarily other than the minister or an assistant minister. So hybrid bills would be the last type of bill that we can see here. And hybrid bills may be of general application, is intended for general application, but somehow it would actually affect a particular group of people in an, adversely. So that's why they will still have to treat. They cannot just like use the general application without considering how it may affect certain group of people. So then if that happens, then it will actually be debated as hybrid bills. So here we can see the parliamentary stage before we go into the pre-parliamentary stage. So before we go, before any bill is being brought into the parliamentary sitting for reading and debate and being passed by the parliament, you actually go through some processes and procedures in relation to pre-parliamentary stage. So here we can see that we actually have 7 pre-parliamentary stage. And the first being the policy or regulatory proposal. Second would be the research. Third is consultation. Fourth, cabinet approval on policy and regulatory proposal. And fifth is drafting instruction to Attorney General Chambers. And sixth, drafting of the bill. And 7 is cabinet approval on the bill. And then that bill will actually be brought to the parliament for it to be read and debated by among the members of the parliament. So I will now break them and try to explain a bit more on each of the stages that we can see in the pre-parliamentary stage. The first being the regulatory proposal is actually your buy-in. As you can see, these are some of the newspaper cutting in relation to regulatory proposal. So it is basically a buy-in by the government, buy-in by a ministry to push for certain agenda or to push for certain issues to be resolved by passing legislations. And this is something that there need to be like some sort of political will and buy-in that is already available before we could actually proceed with the next stage of the pre-parliamentary procedures. So here you can see like Undang-Undang Kekang Berita Palsu was in relation to the Anti-Fake News Act, as well as the sexual harassment on children. So without all of this regulatory proposal, it would be difficult because you don't actually have the champion to bring through the process of passing the legislations until the very end at the parliamentary stage. So for research is basically conducting feasibility studies before we start drafting the bill. So what are the things that you actually do during a research? So number one, we need to look into the existing legislations to avoid duplication or overlap, because sometimes certain activities are already regulated by certain implementing agencies, and this may not be easily available. The information may not be easily available. Therefore, during the research, this is when we try to highlight, is there any overlapping or provisions in relation to existing legislations, as well as the proposed legislation, or the amendment to the proposed amendment to the existing legislation. So the second thing that we would do during a research is that we actually would benchmark with international jurisdictions to adopt best practices. And the third is we would also look into legal issues, as in whether or not the proposed legislation is ultra-virus or inconsistent with the federal constitution. And the fourth one, the research will also include the financial implication to the country, as to whether or not it will cost more money to the government to implement certain laws, or like regulatory the compliance by the public, will that require certain costs to be absorbed by the government? All those sort of things are also important to be highlighted during a research, as well as social economic study, because a lot of our laws also affect public interest. That's why social economic study is very important, especially when our country is quite diverse in terms of ethnicity, in terms of social classes, and in terms of income. So social economic study is also very important to be done in order to see whether or not the proposed legislation is feasible to be implemented. And it goes, and this brings to the last bit of research, where implementation of new law is basically, sorry, can we, so implementation of the new law is basically, when it comes to, the research will also need to highlight certain plan in order for the new law to be implemented. So basically, you don't, whenever you want to introduce new legislations, you don't necessarily immediately enforce without having certain plans in terms of implementation. So this will also be included in the research before we can actually move on to the next pre-parliamentary stage, which is consultation. So consultation, if you want to look at it at a very broad perspective, you have two stakeholders that you want to engage. Number one is the government agencies and the federal ministries, and the second is the public in general. And how do we actually determine who? Because under the federal ministries and government agencies, as well as the public, you have various stakeholders that you want to engage. So in order for us to do consultation, we will have to conduct stakeholder mapping. And since 2013, every new legislation or legislation related to businesses, investment and trade to be amended are required to undergo regulatory impact analysis, which include public consultation. And on this note, I just want to highlight that this series talks about the understanding Malaysian regulations, but moving forward, we do intend to conduct webinar in relation to regulatory impact analysis as well as public consultation. And this is something that is very, very important, because without public consultation or regulatory impact analysis, then we won't be able to adhere to the good regulatory practice principle. So that is why we would want to look into consultation and regulatory impact analysis before we can pass any new legislation. So if you can see in the table in this slide, there are subject matter and stakeholders. I just want to highlight some of the stakeholders that we would usually engage on consultation. So matters which have financial implication, it is very important for whoever that is proposing the new legislation to consult the Ministry of Finance. Similarly, for matters relating to public service, it is compulsory for them to consult Public Service Department. And for criminal matters, then we can see that you have to consult the prosecution Department of Attorney General Chambers, Royal Malaysia Police, Malaysia Anti-Corruption Commission. So as you can see, like, the stakeholders vary in accordance to the scope of the proposed legislation. And I think I just want to highlight a few of our examples that the kind of consultation that we can actually do. So here, this is actually the public consultation that we have done for to develop a guideline to regulate short-term residential accommodation. So before we want to enforce the requirements, or we want to bring the guideline to the Parliament to be debated or to be passed by the Cabinet, we will have to go through consultation. And these were the ways and methodologies that we actually adopted to conduct the public consultation. So here we can see that we conducted open house meeting. We can also do consultation via Unified Public Consultation Portal, where you are able to upload your public consultation document, and the public is able to give comments on what they think about the requirements or whatever they think on the new legislation. So we have also engaged the stakeholders from the government agencies as well to see the feasibility in implementing the requirements under the guideline. So let's just take a look very quickly on the video that we have here. This was done during the open house meeting. And as you can see, that's me looking quite confused. No, not really. I was very happy to be there. And that person was trying to ask for clarification in relation to the requirement under the guideline. So, which is why we explain. So during public consultation, you don't not only that you're able to gauge the reception of the public in trying to adhere to the law, but it's also important because you can actually clarify to the public, because some of the messages may be lost in the document, which requires further elaboration. So consultation is very, very important. That's why I'm spending a bit more time here. And let's just take a look at the next pre-parliamentary stage, which is the Cabinet's approval on policy and regulatory proposal. So once we have conducted the public consultation, we have amended whatever proposed legislation, whatever requirements that that might not be feasible to be implemented, that particular proposal will then have to go through the cabinet of the government. So why do we have to do this? The ministries are required to obtain cabinet approval on matters relating to regulatory proposal. So examples that we have highlighted here is establishment of statutory bodies, government taxes, etc. So the content and how do you actually get this policy or regulatory proposal from the cabinet? This is where we actually circulate the memorandum Jemaah Menteri to related ministries, including the Attorney General Chambers. So when we circulate, then they will actually give their input and comments and feedback in relation to the MJM. And usually MJM contains, among others, the background of the proposal, government consideration, timeline, and implementation plan. So once we have received or obtained the approval from the cabinet on the regulatory proposal itself, then there will be an instruction to the Attorney General Chambers on the drafting of the legislation. So the Attorney General Chambers will have to draft the bill, but in practice, what happens is the instruction will include the draft bill and explanatory notes on the provisions under the bill. So what this means is that whichever ministry or government agencies that is championing to bring through the new legislations or amendment to existing legislations will typically draft the bill themselves. So once they send it to Attorney General Chambers, is for them to make sure that they get clearance from Attorney General Chambers, maybe in relation to certain terms that are being used, maybe in relation to style, maybe in relation to content. But yeah, generally the Attorney General Chambers wouldn't actually draft the bill unless they are being asked to. Usually the federal ministries or the government agencies will pass to the Attorney General Chambers and a bill that is already being drafted by the person in charge. So here on the side, you can see there's Article 145. This was actually an excerpt from the Federal Constitution, and it says the role and responsibility of the Attorney General Chambers, where they will have the Attorney General will advise the cabinet or any minister in relation to development of legislations. So in general, that's what this particular article is providing. So if you want to look into more details, then you can have a read on whatever the article is, the article has mentioned. Following this as well, we can look into the general content of drafting instructions. So drafting instructions would typically include 15 of this content. Number 1 being the policy authority, and then the legislative priority. Number 3, background. 4th, purposes. 5th, means to achieve the purposes, which is your implementation plan. 6 is impact on circumstances and law, which is something that you can actually do when you conduct regulatory impact analysis. 7 would be related proposals. 8 is affected provisions and consequential amendments. Affected provisions and consequential amendments is, this is why drafting legislation is very difficult, because not only you are drafting in silo, you will have to make sure that there's no inconsistency with other legislations as well. And if there are inconsistency, how do we rectify such inconsistency? Which is why we have also the affected provisions and consequential amendments, especially when it comes to when it comes to amendment to existing legislation itself. So number 9 will be commencement. 10 is application, saving, and transitional provisions, which is also very important because without application and saving and transitional provisions, you don't scope out on the applicability or the you wouldn't be sure about how to impose certain law without the application, saving, and transitional provisions. Number 11 would be legal opinion and case law. If there is any lacuna in the legislation, we do rely on case law and legal opinion to clarify certain big part of the legislation. So this will also be included in the drafting instruction. So number 12 is administrative or judicial review. 13 is regulation making powers. So as we can see last week, we did talk about only primary legislations go through parliamentary stage, right? So for statutory legislation, it would actually be passed by the ministry itself. That is why typically in the drafting instruction, it will also include regulation making powers for the government agencies to pass in order to implement the provisions under the primary legislation. Number 14 is consultation with other departments, which is again the engagement with the relevant stakeholders. And number 15 would be the instructor details. So that's generally what we can see in the drafting instructions. And this is just a very because it's like 3 o'clock, let's try to lighten up the mood a bit. So here, what you can see is there are like the illustration of the importance of having good drafting instructions, because in the lawmaking process, there are various stakeholders are involved. And that is why in order to streamline the understanding, in order for us to achieve the goal, we need to be able to have the drafting instruction to be as clear as possible. If not, then you will get like this. So as you can see, like the ministry is asking for like something really, really advanced. And then the ministry's official may not be able to like, may somehow, miss out certain things. And the stakeholders want something else. And the drafting instructions would probably say something else. So the public may not understand anything at all. And then we can actually say at the end of it, like what was actually needed. So yeah, like I said, it is very important for us to streamline the understanding and the understanding of all parties before we can actually start drafting, before we can implement or pass any legislation. So after we have, after the instruction has been given to the Attorney General Chambers, it goes into the drafting stage. So here I just want to highlight what are the roles and responsibilities of drafter. So number 1, they actually hold meetings with discussions with PUU. PUU are generally the legal officers in the ministry or government agencies. Officers from the ministries, department agencies, agency chambers officers from other divisions. The drafter should also identify legal problems and solutions. And thirdly, they have to assess relevant legal risks. And fourthly, they have to do research and understand and apply the law using reference material. In particular, the one that I'm highlighting here are the ones that we really need to look into. Like I said, the federal constitution, you cannot pass any legislation which might be inconsistent with the provisions under the federal constitution. The Interpretation Act 1948 and 1967 is very, very important in relation to application of the law in terms of definition and scope. The Hansard will then be able to capture anything that has been debated in the parliament. Dictionary, we have legal dictionary. We can't just introduce common terms that may have different legal implications. So it is also important to use certain terms only, and various other reference document. But these are some of the ones that we want to highlight that is very important in relation to drafting stage of primary legislation. So this is one of an example of a bill that is being drafted. This one in particular, it was for SPAT before it was for SPAT, and this is just generally like an example of a bill. It says Rashid because you're not meant to share it, but it's okay because this is like this is like previously, they has been passed, so we can actually share this with you. So for Cabinet's approval of the bill, before this, we require the Cabinet's approval in relation to the regulatory proposal itself. But now, once everything has been decided, one of the last one that we actually need is the Cabinet's approval on the bill itself. So what is included in this document? So the bill will usually include the BM English version of the bill, which has been prepared by the AGC, or it has been prepared by the legal officers of the ministry in charge, but it was also approved by the AG chambers. So it will also include with the table of amendments, this one in particular for legislation being amended, and it stated whether the new bill or amendment to the legislation required to be referred to the special committee. Mostly they do not, unless there are certain issues that they want to discuss. And lastly, it does contain recommendations and summary. So the timeline for MJM paper, it has to be circulated to relevant ministries and implementing agencies to get their input at least within 4 weeks before the tabling of the bill. But for certain legislations that require to be prioritized, it can be circulated in a short period of just 2 weeks before the tabling of the bill. But this is not the general rule. These are only given to certain policy that the government really want to push for, and it has to be, it can only be effective if it's done by way of legislation. So those kind of circumstances will be given exemption, where the MJM paper can be circulated within just 2 weeks instead of 4 weeks before the tabling of the bill. So once that is done, if you can remember my previous slide, there are 7 pre-parliamentary stages. Now we're looking into the parliamentary stage. Here we have the first reading, and after we have the first reading, we go into the second reading. It goes into the committee stage, and then third reading, and then once it is okay, it will be debated in Dewan Negara, and then it will receive royal assent, and then it will be published. I will break down all of these stages in my upcoming slides. So here we can see the first reading is just basically formality, where the minister in Dewan Rakyat reads out the title of the bill. So the speaker will then set a different date and time for the second reading, and usually within the next few days, unless the government claims that all readings be done immediately. Like I said, there are already legislative process and administrative provisions in relation to tabling of the bill, but also if there is certain political will that there is a need to pass certain legislation quickly, then there are exemptions to be given. Like you can see here, if the government maintained that all readings to be done immediately, then the minister wouldn't even have to wait for the next few days. So, but typically they will have to wait for the next few days before they go into the second reading. So at this stage, the bill goes through parliamentary debate on its principle and contents, and the draft copies of the bill will be distributed to all members of the parliament for a few days before the second reading. So after the second reading is completed, it goes into the committee stage, where any member of the parliament can call for a special committee to discuss the technical details of the bill. But however, the speaker can also disallow and promptly call for the third reading if he thinks it is not necessary. So the third reading is the actual voting process, and a 2/3 majority is required to pass the bill. Should the bill be passed, then it will send to Dewan Negara to also be read and debated in Dewan Negara respectively, which we can see in the next slide. So like I said just now, after it has passed Dewan Rakyat, it goes into Dewan Negara, and the debate in Dewan Negara goes through a similar process as it did with Dewan Rakyat. So you will have your 3 readings. And as I also think it's important to note that Dewan Negara can only delay a bill's passage by a maximum of 1 year before it is sent straight to the Yang di-Pertuan Agong. So meaning to say, like, even because Dewan Negara are the constituency of Dewan Negara are typically your senators. So the MPs they all sit at Dewan Rakyat. So that's why there's only so much that Dewan Negara can do. If they refuse to debate or they refuse to look into the bill, within 1 year, the bill will immediately just go to YDPA to get the royal assent. So like I said here, once the bill has been passed by Dewan Negara, it will be submitted to the YDPA to obtain his royal assent. So I just want to say that Article 66 4A of the Federal Constitution that the bill will become a new law after 30 days, even if the Agong does not consent to it. So once it has received the royal assent, it will go straight to the publication, where no law shall become into force unless and until it has been gazetted and published in the Government Gazette. So if you go into e-Federal Gazette, you can actually look into any new legislation that has been passed. For example, your movement control order, you can actually look into the Government Gazette and find them there. So this is something that is available to the public. So we are actually done with the parliamentary stage, and now we're going to look into the State Legislative Assembly. So here we have like 3 broad things that we need to look into. Number 1 is the introduction of bills. We have is the same one as the one that we saw at the parliamentary stage, where they have the private members bill, the private bill, public bill, and hybrid bill. And then the bill will be passed by the State Legislative Assembly, and then the ruler will signify his assent before every enactment can be published in the State Gazette. So here is the legislative procedures in the State Legislative Assembly. It is quite similar to what we saw at the federal level as well. You have your first reading and second reading, and then you go into the Committee of Bills, where it either go through the Select Committee or Committee of the Whole Assembly, and then it goes into the third reading. And once that is done, it gets royal assent by the ruler, and then it will be published. I'm just going to go through very quickly on the breakdown of each of these procedures in my next slide. I'm going to skip on the pre-assembly sitting stage because it is quite similar to what I've discussed before, but I just want to look straight into the assembly sitting stage, where we have the first reading, where Menteri Besar or member or on behalf of the Menteri Besar may present a bill, and then when a bill is presented, the title of the bill shall be read at the clerk at the table and be ordered to be printed. I just want to highlight here, like the procedures are quite similar. It's just that we have different stakeholders who are carrying through these procedures. So instead of MP in Parliament, we actually have Menteri Besar that does it. So after the first reading, it goes into the second reading. And for it to be done in the second reading, the bill has to be circulated to members before the second reading. And the debate during the second reading will cover the general merits and principle of the bill. So for the third reading, the debate shall be confined to the contents of the bill, and any reasoned amendment which raises matter not included shall be out of order. And amendments of the correction for errors with the speaker's permission may be made before the question of the third reading. So this is something that we can look into before the third reading is being conducted. So like I mentioned just now, it will go through the Committee of Bills. Like I said, it's either we have the Select Committee or Committee of the Whole Assembly. So Select Committee, typically all bills under State Legislative Assembly will typically go into the Committee of the Whole Assembly unless the member of the Legislative Assembly specifically requests for it to go to the Select Committee. So what is a Select Committee, right? So when a bill has been amended in the Select Committee, the whole text of the bill as amended be printed as part of the report of the Select 42 Committee. But for Committee of the Whole Assembly, the procedure in the Committee of the Whole Assembly on the bill can be found at Standing Order 57. So if any member before the conclusion of the proceedings on a bill moves to report progress and such motion is carried, the Speaker shall report progress to the Assembly and ask its leave to sit again, and a day for the resumption of the proceedings shall be named by the member in charge of the bill. So once it has gone through the committees, it will be submitted to the ruler for his assent. And then as soon as practicable after the assent of the ruler has been given, every enactment shall be published in the State Gazette. So that is as far as what we can understand in relation to the State Legislative Assembly. Now we're going to look into the third level of the government, which is our local authorities. So local authorities, where do they get their power to actually make the law, right? So if you look into Section 2 of Local Government Act 1976, it says that bylaws in relation to any local authority means any bylaws made by the local authority. And how do they make these laws? This is actually provided under Section 102 of the Local Government Act, where local authorities are empowered to pass bylaws in relation to certain number of matters that are specified under the Local Government Act. An example of local authorities, like DBKL, Putrajaya Corporation, and BPJ, these are your local authorities. So each of these local authorities are actually empowered under the Local Government Act to pass their own bylaws. So here, I just want to show you the legislative process for bylaws under the Local Government Act. At the top, we can see that is the Ministry of Housing and Local Government. Why we mention this is because KPKT is tasked as the ministry responsible for the enforcement of the Act. So how do we know that KPKT is the ministry responsible for the enforcement of the Act? This is where you can see on the side here, we have a little box that says, under the schedule, under the ministers of the federal government order, it will stipulate the ministries and the number of legislations that are under their custodian. So for the Local Government Act, it's actually under KPKT, and KPKT then has entrusted the power to implement the provisions to Jabatan Kerajaan Tempatan, which is the local government department. And then you can see the Local Government Act, it gives power to the ruler in council. Sorry, let me just bring you back. As you can see, there are two dua cabang to the bylaws, and this is because it's quite unique because we have federal territories, but we also have all the varying states. So for federal territories, because under the Local Government Act, it says that the ruler is empowered to pass any bylaws. But for federal territories, so for states, typically the ruler would be your Yang di-Pertuan Besar or your Sultan. But for federal territories, the ruler in charge is actually the Ministry of Federal Territories. And that is why we actually have two cabang to the varying way of making, the two cabang to the process of passing bylaws. So let's take a look at the KW1 first. So the Local Government Act provides KWP to be a state authority for federal territories. So one of the example is a DBKL, and DBKL is a local authority as defined under the Act and is an example of a PVT of the under the purview of Ministry Federal Territories. So once DBKL is tasked to be a local authority, DBKL then now is empowered to make bylaws for federal territories. So similarly, for state authority is the same as well. The council provide ruler-in-chief or governor-in-council to be state authority, and the state authority provide that city council, municipal or district council to be PBT for states. So each of the state BBT will also be empowered to make bylaws. So I just want to say that bylaws are enforced in accordance to the jurisdiction of local authorities. That's why each state can actually make their own, each local authority can make their own bylaws, especially because it usually covers things in relation to licensing, like all the small administrative or not heavily regulated activities will actually be overseen and regulated by local authorities. So I just want to say that this would be at the end of the legislative process for the Parliament for Parliament, State Legislative Assembly, and local authorities. And after this, I'm going to pass to Nick to follow through with the rest of the presentation.
And because we're running out of time, so if you have any questions, you can feel free to ask on the question section on the right. If not, you can always email us, or you can find our contact details at the end of the end of the slide. Okay, overall, you guys are still awake, right? Okay, so I'm going to explain about this statute. Basically, I'm going to explain to you on how to read a statute, because I get people tend to ask the same questions, like how do we read statutes? What is the reference number? What's preamble? What is the clause? We'll go through one by one. Okay. So the first one, next slide, please. Is the arrangement of sections. So it is provided at the beginning of any act that the arrangement of sections. It is done for easy reference and reading. So if you take a look at the act shown on the right-hand side, they will explain like, okay, number 1 to number 50. So it's called section, but for normal act, it's called section. But if it's for federal constitution, they call it article. So it is separated between parts, sections, and subsections. Next. Next slide, please. So in order to read a section, this is how you read it. Guess which is the section, subsection, paragraph, and subparagraph. If you look at the example, so section 9 is the main one. So how we read it is section 9, subsection 1, paragraph A, and if they are done, it will be called like subparagraph A or 1. So that's how you read an act. So we'll start with section, subsection, paragraph, subparagraph. Next. So second is the reference number. Reference number is the number of the act or the subsidiary legislation. So there's 3 types. The act number itself, the PUA number, and PUB number. I get asked this question a lot. What is PUA and PUB? So I will explain later at the end of my slide. So just asking you to wait for the answer. So you cannot turn off this slide just yet. So in order to read the act, you just go through the first page and it will state, okay, for example, this one is Prevention and Control of Infectious Disease Act 1988. It will state there Act 342. So currently there's more than 800 primary legislations in Malaysia. If you look at the Attorney General website, you can find the whole list there. Okay, third one is title. So there's short title and long title. So for short title, it's actually the name of the act itself. So normally under section 1, they will state that, okay, this act may be cited as the name of the act. So in this case, it is the Prevention and Control of Infectious Disease Act. As for long title, basically they will actually explain the general scope of the legislation and becomes part of the act. It is typically found in the primary legislation only. It is to interpret the meaning of an act when there is no clarity in interpreting a section. So basically on the first page, we will normally find a paragraph that explains the content and the scope of the legislation. So for example, for the Prevention and Control of Infectious Disease Act, it states that this act is made to amend and consolidate the laws relating to the prevention and control of infectious disease and to provide for other matters connected therewith. Meaning that before this act was made, there was other regulations and also rules pertaining to infectious disease, but they combine it and actually consolidate the laws and turn it into just one act. So that is the long title. The next one is preamble. Preamble will explain the purpose of the act that was enacted and its scope. So basically it's the same as long title, it's just that it's slightly longer, and typically they will put the word whereas. Okay, next slide. So the fifth one is the enacting clause. So for an act, it is to inform who actually passed the act. So if it's a primary legislation made by the federal government, it is passed by the parliament. So for the first example, it will state that, okay, this act is enacted by the Sri Paduka Baginda Yang di-Pertuan Agong, that's highlighted by Liya. He will actually assent on the bill with the advice and consent of the parliament. So basically parliament made the act. And for enactment, which is, if you tune in during our last session, we already explained enactment is a primary legislation made by the State Legislative Assembly. So it will state that, okay, this enactment is enacted by the legislature of the state of Selangor, for example. Okay. So next, moving on to the commencement date. So commencement date is when the date the act is enforced. So basically there's two dates involved. First is the gazetted date. Gazetted date is when the parliament passed it, but dia tak enforce lagi. You cannot simply use it. Normally, in order to use it, the government will actually issue another subsidiary legislation. It's called the appointment of date of coming into force, whereby they will state, okay, this act will come into force when and when. Sometimes dia akan cakap like, okay, this act will come into force in KL in January 2020, but in Selangor it will be in February 2020. So that one is the date in force where you will actually use the act and start to implement. Okay. 7 is on the application. So it is to state the limit of application of the legislation. So it can be limited to the state and federal government in a certain period of time, limited to certain group of people, and limited to certain territory. For example, the Prevention and Control of Infectious Disease Act, basically our current regulation pertaining to COVID and MCO, it falls under this act. So this act may be cited as the Prevention and Control of Infectious Disease Act and shall apply in Malaysia, meaning it's for the whole of Malaysia. But for example, the second example, which is the Islamic Family Law State of Selangor enactment, it states there that this enactment shall apply to all Muslims living in the state of Selangor and to all Muslims resident in the state of Selangor who are living outside the state. So basically, it's for limited to certain group of people and limited to certain territory. Moving on to the next slide is the interpretation clause. So basically, if you read an act, if you don't understand the meaning, then you can actually find the interpretation of each word stated, the main ones, inside the interpretation clause. Usually it's found under section 2, section 3, whereby it will state, okay, in this act, unless the context otherwise requires, this particular word means something, something. So for example, this one, like authorized officer means any medical officer of health and any health inspector or any officer appointed by the minister under section 3. So that's where you get the definition. It's just to avoid any like repetition and doubt. If you don't want to just keep on explaining the same meaning, so they already have like a specific clause on that. Okay, the next one is the main and enforcement provision. The main provisions are substantive and administration provisions. It includes the main provisions such as appointment of authorized officers, who can do this, who can do that, the license, the registration, and power of authorized officers. And the second part is usually the enforcement provision, which provides for the powers of investigation and enforcement of an act. So basically, as an example, under the Prevention and Control of Infectious Disease Act, I'll just say Act 342. Tak enough first. I need to exercise. Okay, so under Act 342, if you look at the main provision, you check up the appointment of authorized officers who's in charge to actually keluarkan all of the regulations pertaining to MCO. Sekarang kan kita banyak tengok on TV, will be the DG of health. And then the enforcement provision will lay down like what they can do on the power and what they can do in order to take action against people who actually disobey the regulations. Okay, next. Next is the general provision. Usually it is found at the end of the act. This is normally found in all of the acts. Usually it's at the exemption, power to vary schedules, power to make regulation, and amendment as seen in the example given. So just to illustrate, so power to make regulation, usually inside the main act, it will state that, okay, for this particular act, the ministry in charge, the minister in charge has the power to make the regulation. So for the Act 342, the person who has the power to make regulation is the Minister of Health. Okay. So lastly is the final provision. There's about 4 types. First is the repeal provision. The function is to repeal an act. The effect is that the legislations will no longer have any effect. So inside the act, it will state, okay, this particular act maybe act yang previously prepared has been repealed and replaced by this new act. Secondly is the savings and also the transitional provisions. For savings provision, it's just to save like some clauses. For example, if you make a certain act, ada certain powers. So if, for example, the act is repealed, then you can have a saving provision to say that, okay, this particular section is still valid no matter what. So in respect of transitional provision, it is more or less the same as savings provision. It's just that transitional provision comes from the next act. It will state that, okay, inside the new act, it will state, okay, based on the previous law, this particular section is still valid. Although the act has been repealed, it is still valid. We can still use it under the current laws. Okay, and lastly is the schedule. Schedule usually is the technical terms and all found at the end of the act of the regulation. So for example, under MCO punya regulation, the main one, they will state that, okay, only essential services are allowed to actually connect their services and do their work. But then what is essential services? So essential services, the definition can be found under the schedule kat belakang. So they will list down kat panjang dekat situ. So the technical details can be found at the back of the act or regulation. So it can include lists, charts, arrangement, and even pictures. All right. So the second question that people normally ask, so how do you actually interpret legislation? Okay. The power actually lies with the judiciary, not typically judge will actually interpret the legislation. So what is a statutory interpretation? It is a process where the judiciary needs to interpret the statutes in order to apply the law that has been legislated by the legislators. So it is necessary because when the legislators make the law, it will normally be general and broad in nature. So that's the reason why the judges have to interpret the law. But how do they do it? Boleh kesuka hati je. So the judges are actually assisted by statutory rules and also the common law rules. Okay. So for statutory rules found in statute, in Malaysia, there's 3 statutes on statutory interpretation, which is the Interpretation Act 1948 and 1967, which has been consolidated. Secondly is Interpretation and General Clause Enactment of Sabah, which is applicable to Sabah enactments only. And lastly is the Interpretation Ordinance of Sarawak 1953, which is applicable to Sarawak Ordinance. So if you cannot find the definition inside the interpretation clause of the Act, you can actually refer to the Interpretation Act and find the definition. So like I've mentioned earlier, most statutes, you can refer to section 2, whereby they will actually list down all of the definitions for the main words that they use. Okay. So that is for statutory rules. How about the common law rules? So for common law rules, if there's no statute that interprets the law, the definition of the law, the judge can actually interpret the laws itself by following these 4 rules. So first is the mischief rule. It gives judges the flexibility in deciding what the parliament meant. So the rule is actually based on the Hayden's case. So it was stated that for the true interpretation of statutes, the court has to consider the following. First, what was the common law before the Act? And second, what was the misuse and defect for which the common law did not provide a remedy? Third, what remedy had Parliament decided upon to cure the misuse? And fourth, what was the true reason for the remedy? So that is mischief rule. And the second rule is the literal rule. So under this rule, the words in the statute must be given their literal meaning. So the judge should give words in the statute their literal meaning, that is their plain, ordinary, and every meaning, even if the effect of this is to provide what might be considered an otherwise unjust or undesirable outcome. So the next rule is the golden rule. So the golden rule is generally considered to be like some sort of extension or a modification of the literal rule. The words are given their ordinary and literal meaning unless the outcome is absurd or repugnant, then in which case a more suitable alternative meaning will be given. So it is applied in circumstances where the application of the literal rule is likely to result in an obvious absurd result. So this one will be done by the judge himself. And lastly is the purposive approach. It is sometimes argued that the purposive approach is the same as mischieful. So what differs between these two is that for purposive approach, it goes further by seeking to determine the Parliament's intention in passing the particular act. So in Malaysia, the approach has received statutory recognition under Section 17A of the Interpretation Act, which states that interpretation of a provision of an act, a construction that would promote the purpose or object underlying the act, whether that purpose or object is expressly stated in the act or not, shall be preferred to a construction that would not promote that purpose or object. Okay, but this is not as exhaustive. We can also look at other types of internal and external aid, such as illustration. For example, in contract acts, they will actually, under some of the section, they will give like illustration and examples on how to interpret particular sections. And schedules, like I've highlighted earlier, it will actually list down the definition, which is more technical and long. Third is judicial decisions, whereby the judge will interpret the statutes in peri materia. The thing about law is that they tend to use all these like life Latin term, but actually peri materia, this saja nak takutkan. But peri materia ni, it means that is the same decision made by the court. So basically, if in a particular case, a federal court decides that the definition of X is upper, so the subordinate courts will follow that definition. So lastly is the previous and subsequent statutes on the same subject matter, whereby you can find for example, under the regulations, if you can't find the specific definition there, you can refer to their main act, the Ibu Act, the primary act on the definition. So if you were a judge, which rule or approach would you apply and why? Okay lah, I don't know why I asked this question, you cannot answer, but do let us know your opinion on this. You can actually email us at MPC Secretariat. We would love to know your answer to see whether you are actually concentrating or not. Okay, last part I will explain on the terminologies because people tend to ask the same question because they don't know the definition and the differences. So first, what is the definition and difference between PUA and PUB? So PU stands for Pemberitahu Undangan or legal notification. So there's two types. PUA contains royal proclamation, orders, rules, regulation, and bylaws. PUB pula, it contains all subsidiary legislations other than that which is required to be published in the Legislative Supplement A and generally deals with appointment and notification. So that's the definition of these two. So next one is shall and may. So how do I differentiate? So basically shall, this one you just use the literal approach. Shall means an imperative command. It means that you have to do it, wajib. For example, in a particular provision, it states that the notice shall be sent within 30 days. So usually shall used here is in the mandatory sense. You have to do it. But for me, it is a choice to act or not, or a promise of a possibility as distinguished from shall, which makes it imperative. So it's your discretionary whether you want to follow it or not. In statutes and sometimes in contracts, so it's just your discretionary whether you want to follow it or not, and then the judge will interpret accordingly. So moving on to the next slide, the last slide. Okay, another example, people ask, okay, what is repeal and what is revoke? So for repeal, it's normally used for an act. So if you want to like terminate or not terminate, like to cancel a particular act, you use the term repeal. But for subsidiary legislation, you use the term revoke. How about amendment and revise? So amendment, if there's any amendment pertaining to the laws, which is very crucial, you have to call it an amendment. But if revise, meaning that it's just like maybe some technical error or maybe spelling or minor matters, so they'll call it revise. So I think that's about it. Thank you. Ready to answer your questions.
Thank you, Nick and Liya. I think we open questions. So I received few questions from the participants. Okay. All right. Let's see. Okay. One question. Selain daripada PUA dan PUB, terdapat GN yang mempunyai number saja. Apakah beza atau fungsinya? Yeah, that is one of the question. Yeah, Liya or Nick?
I think this one goes to Nick, right?
Sorry, can you repeat the question?
Okay. Selain daripada PUA dan PUB, terdapat GN. GN yang mempunyai number sahaja. Apakah beza atau fungsinya? G for and New York.
Alright, thank you, Salam. So basically, GN is short for Gazette notification. So when has it been gazetted?
GN is stand for
Gazetted notification.
gazetted notification.
Yeah. So like last week when we talked about the varying sorry, it's a bit echoey. Okay, so last week when we talked about the various types of legislation, so we have notification as well, right? So GN is just generally trying to say that it's gazette notification. And it's it describes the varying types of statutory legislation.
Okay, and then question from Cik Khairul Zaman. Why do you need two-third majority for bills that do not affect the federal constitution?
Okay, actually you are right. The federal constitution, only matters affecting federal constitution will require two-third majority. If not, any legislation can be passed by way of simple majority. And I just want to highlight as well, like based on my experience going to the parliament, what I realized that usually the way that the speaker will ask for the vote, they don't even need to write down their votes. Actually, it's just a matter of they say, okay, are you agreeable to pass this bill? Then if they can hear the sound of the voice to say yes more than no, then it means that the bill can be passed, unless the members of the parliament actually request for the votes to be counted manually.
Okay, thank you. Yeah, I think clear. Question from Cik Haji Zuhair. Hi, Zuhair here. I have a question. 1 hour legislative process. Sorry, I think on our legislative process, is it possible for a bill involving public urgency matters be exempted from Dewan Negara stage? Meaning to say, the debate only take place in Dewan Rakyat. I think maybe in these circumstances, during MCO, is it possible to, government to come up with regulation during this time?
Okay, that question is a very popular question. I'm sorry, before I continue, can we do something about the echo? Because when I speak, I can hear myself again.
Echo. Let me check.
Okay, let me just try. Okay, I think it's better now. Yes. Okay. Okay. Coming back to the question, whether or not, let me just talk about passing legislations in general, especially during this time, right? The problem with this question has been asked a lot, because especially if you want to pass certain legislation at a very short period of time, because as we understand that the legislative process is quite lengthy, it does take a lot of time, even before it goes to the parliamentary stage. However, if you look into the standing orders, there are no provisions in relation to expediting or cutting or skipping a certain procedure. You still have to do it. But the simple answer is that these processes can be expedited if due to political will. So for example, like if you want to pass legislation, there will already be a queue of legislations that will be debated. There will be a queue of bills that will be debated during the parliamentary sitting. So for example, if we do want to pass COVID legislation cepat-cepat, then basically that bill will will cut the queue. So this is something that has been explained to us by the AD chambers as well, because we asked this question before. Is there any provisions or allocation to skip certain procedures so that we can pass the legislation quickly? But the answer is like they don't. However, there are certain things that they can do to expedite it. And this has been proven before. Let me just pull up some example. For example, we had this experience when we drafted the Dana Harta Act in 1998, which was enacted in a period of just 1 month during the ASEAN financial crisis, which is really, really short when it comes to legislating primary legislation that is passed by the parliament. So it can be done, but even though it was passed within a period of just 1 month, it still went through all the proper procedures that has been set up by the parliament. So that would be a general answer. Of course, this is a very complex question, but I hope that clarifies a bit.
Thank you, La. I think I will move to next question, and I will try my level best to complete all the questions, because I received feedback from previous session. Request that their question to be answered. So I will try my level best. So next question from Liana. She asked about for concurrent list, the bill is tabled at which platform, whether it's at the parliament or at the state legislative assembly. Sorry, you need to unmute.
No worries. This happens all the time. Yeah, but I was saying for concurrent list matters, it really depends on which party is affected by the legislation. So for example, because concurrent list, I think the question comes from the fact that concurrent list covers both state and federal matters. So both federal and state are actually allowed to make the laws. So it really depends on who is the champion that wants to bring through the bill through the parliamentary stage. So if it's a ministry that wants to do it, then it will go to the parliament. But if it's not, then it goes to the state.
All right. Okay, good. Mr. David Yap has two questions. I think I will ask these two questions. Question number one: if there are inconsistencies between English version and the Bahasa version, how do we know which version prevails? Second one,
Okay.
why is the Interpretation Act consolidate two acts instead of repealing the earlier act and enacting the new act? These two questions.
Okay. I will take this question. Oh, Nick. Okay, go ahead, Nick. Go ahead.
Oh, sorry. Okay. So for the first question, the answer is English language shall prevail. This is stated under Interpretation Act itself. So if there's any inconsistency, then English shall prevail.
Okay, thank you. Second question, why is the Interpretation Act consolidated two acts instead of repealing the earlier act and enacting a new act?
It's generally because the Interpretation Act provides that part of the act, that is the interpretation and general clauses, is repealed with effect from 18 May 1967. Insofar as it is a federal law, but it will continue to apply as any written law to which it is applied immediately before 18 May 1967. So this question, the answer is very, very historical. There isn't that's why we came up with like the varying types of primary legislations, which include the Consolidated Act as well. So, but also you can see it was done only for the Interpretation Act based on historical context. But this is not generally how the Parliament or the government passed legislation.
Okay. Thank you. And then a question from Puan Siti Najiha. Under MCO, must all state government and local entity strictly follow MKN, Majlis Kehormatan Negara? Are they allowed to enforce their own additional regulation? Example, operation hours for business. When do the lower or upper house need? Okay, that is the question. During this MCO, so must all state government and localities strictly follow MKN? Can they allow to enforce their own additional regulation?
Okay. Can I take this question, Nick? Okay. Cool. So basically, so MKN is currently the only authority that can issue directives and things like that. But when it comes to imposing certain orders, all states or all authorities can come up with their own laws as long as there is a source of power. So if you want to issue directive or if you want to include additional regulations, it has to have certain powers, and those powers are found under the Act. So if you ask me whether or not they can, for example, a local authority who wants to issue a new legislation, a new order or subsidiary legislation that is issued pursuant to the Preventive Health Act. I can't remember like the full name. But you can't, because under each act they will actually state who is the authority in charge to pass new legislation. So the message here is that yes, they can, if they can find the source of power to issue such order. But if you want to rely on the primary legislation that is being enforced by the National Security Council, like, you cannot do that.
Okay.
So meaning to say, So meaning to say that each of the local authority or each of the state governments will have to look into their own enactments, into their source of power to make sure that, you know, whatever that they are issuing is not ultra virus. It's not something that is, you know, outside of the scope of the power that they have as implementation. Sorry, as authorities in general.
Okay, thank you. One question from Azlin. When do the lower or upper house need two-thirds and simple majority? Got the question? When do the lower upper house need two-thirds and simple majority? When?
Yeah, like I mentioned just now, like if it's a matter relating and it touches on things that will affect the federal constitution, if you are trying to propose an amendment to the federal constitution, then you will need the two-third majority. If not, any other matters would just require simple majority from the parliamentary sitting.
Okay. We have another two questions more from Cik Zuhai, Cik Mohamed Zuhai. Federal level is similar to pre-state legislative assembly process, meaning all GRP initiative must be complied with. The question, federal level is similar to pre-state legislative assembly process. Does federal level is similar to pre-state legislative assembly process? That's question.
Yes, it is similar. They will still have to go through the 3 readings. They will have to still get the royal assent. Like I mentioned, the procedures are quite similar. Maybe some administration, maybe the conduct of the Legislative Assembly might be different because they are governed by different standing orders. But if you look into the processes and if you really look into our site, that you can see it's similar. It's just that you have different authority carrying out those roles and responsibilities. So instead of YDPA giving the royal assent is given by the ruler-in-chief, by the state ruler, or the sultan. So those are just some of the examples of how they are different, but also still very similar.
Okay. In respect of GRP initiative, can you hear me?
Okay.
Okay, may I add for GRP initiative?
All right, please.
So both federal and state level, they have to follow GRP. It's just for us to make sure that it's good regulatory practice, whereby you still have to conduct, during the pre-parliamentary stage, you still have to conduct the RIA, whereby before you actually start to amend or actually change any laws, you have to go through a process called regulatory impact analysis. You have to explain in detail. This is done prior to you sending the bill to the parliament itself. So during the pre-parliamentary stage, so the first time you want to actually introduce a new act or have an idea, you have to conduct the RIA itself. And then with the RIA certificate to say that the RIA has been done and it is adequate, then the RIA certificate will be brought to Parliament or the State Legislative Assembly. So yes, you have to fulfill the GRP initiative.
Okay, thank you, Nick. Cik Ridwan asked about, can you explain the mechanism of block voting? In such an instance, can an MP move to vote against his block voting? So sure what is block voting? Yeah.
Yeah, you know, when I went to the parliament, like this is something that we always discuss. Yes, each MP is allowed to vote however they like. You do not need to follow your coalition. You're allowed, because you are representing your constituency. So my understanding is that you do not have to follow your coalition, and that is the beauty of democracy in our country. It's regardless of which coalition you belong to. Each MP has their own prerogative to make their own decision in the best interest of the people, or of the people that voted for them. So to answer the question, block voting, yes, it exists because usually you want to pass legislation that is in favor of your coalition, but that is not something that is written in stone, and you are allowed to vote against your coalition. And most importantly, like I mentioned just now, most of the time we don't even take down the votes manually. It's just by way of checkup like macam the speaker say, okay, do you agree, boleh tak nak pass this legislation? And then dia kata, okay, saya setuju. So that's just generally it. If they think that the number of MPs saying yes is overwhelming to the number of MPs contesting the bill to be passed, then the speaker will just say like, okay, the bill has been passed.
Okay, thank you. But I think I just received another 2 questions. I think I will try. These are last 2 questions, Liya, Nick.
Sure.
I think I try to try to post and answer this question. And this one question from Ajeng, Mr. Ajeng Jokwan. He asked about, can we have all the question and answer provided to us in written version? I think we just, through this online, there is no written, and then but you can check because this session will be recorded, and then you can go through again this session next time. And then the next question, I think we can highlight this one. Is it possible for AGC to refuse any drafting instruction upon ministry approval of regulatory that is from Ajak. So this one is question from Aizuddin. So last one, Aizuddin asked about, is it possible for AGC to refuse any drafting instruction from ministry upon ministry approval of regulatory proposal? The question is it possible for AG to refuse any drafting instruction from the ministry?
I've not heard of I've not heard of AGC refusing the instruction, but what the AGC can do is that AGC is empowered to give feedback, and they are empowered to also tell the ministry like how the act should be drafted. But I think what we have to understand is that once the regulatory proposal is the buy-in, right? But once the drafting instruction is actually the bill itself. And this bill has been formulated through various of, like I said, if you go through the consultation period and you engage with your stakeholders and you get the buy-in, I don't think AG wouldn't have the power, so AGC wouldn't have the power to say, oh, I'm not going to look at this, because this is basically them following the procedures that has been laid out. So I would say no.
For the current practice?
Yeah.
Okay, so once the ministry has actually prepared the bill, they will pass it to the AGC. So they have to pass it together with the regulatory impact analysis assessment, whereby MPC will actually say that, okay, the ministry has conducted regulatory impact analysis and has fulfilled all of the 7 elements, whereby you have to explain what is the problem pertaining to current regulations, the objective of the new regulations, and you have conducted public consultation with all the stakeholders, you have conducted cost-benefit analysis, and how are you planning to actually implement the new regulations. So inside the regulatory impact statement, you will explain all of this. So basically, once you've prepared the regulatory impact statement, and you have received a certificate from MPC stating that the RIA is adequate, the certificate is brought to AGC, and then AGC will check, oh, okay, you have conducted RIA. So basically, you've conducted like an impact analysis on why you need the current laws and why it is needed.
Yeah. So I think what Nick is trying to say is like, because of you have the regulatory impact analysis, you already have the justifications why you want to pass certain legislations. And AGC is there to facilitate, not to be like an agency to stop. Because at the end of the day, I think this is something that Nick fights. Nick does a lot of RIA. So she understands that, you know, like you're not meant to be a stockholder for anything. It's meant to go through the procedures. It's just a matter of you need to advise the ministry on how the legislation should be drafted. So usually it's just like formatting, macam, you know, that language. They wouldn't touch into the content. Because like Nick said, these are all have been provided in RIA. And at the end of the day, it really is up to the ministry who wants to implement this legislation to debate and fight for this legislation in the parliament.
Okay, I think that's all questions. Thank you very much. We appreciate so much to Liya and Nick. I think your presentation is quite comprehensive. I learned a lot. I think we learned a lot from you. I think we hope we can see you again. I think we will have another session with ZICO, I think another 2 weeks for public consultation. So yeah, we are waiting for your side to present on the public consultation. But for next week we will have a GRP webinar series, which is on the topic Foundation of RIA, of Regulatory Impact Analysis. Speakers from Datuk Uri Sechwan is from former Deputy KSU of MITI, Malaysian Trade. So he is an expert on regulatory impact analysis. So next week on 30th April, you can register our next GRP webinar series, 30th April. Ladies and gentlemen, you can download all the presentations at the handouts box. You can see handout box. So there is a slide presentation. You can download this one, and then also as I mentioned earlier, so we will this session is being recorded, and we will share with you. I think after a few days after complete this recording, and then you can see again our presentations. And then after this session, we will send a survey form, and appreciate if you could complete all the survey form to improve our next webinar session. I think that's all. Thank you very much. We are really appreciate for your time, and then thank you for both of the speakers. I think they done a very good job. Thank you, and see you.
Having us.
Yeah, thank you.